Can hear.
Okay, thank you. So we will discuss today about the new topics that suspension, then we will discuss about the termination, then we will discuss about the force majeure. Okay, so everybody got the notes. Let's go to the difference between the suspension and the termination. Okay, so suspension, you might hear this word. Suspension happen for a temporary reason. So you want to stop somebody. Let's say in job, somebody got suspended. It's kind of a things happening as a temporary action. So if the suspension happening at the project, construction project, they are going to stop the work temporarily. So it's going to be for a certain period of time. Now the suspension can happen for what? Okay, there may be a lot of reason. Maybe unforeseen circumstances, or maybe some changes, major changes going to be introduced, or there may be some disputes happening between the parties. There may be so many reasons for this kind of temporarily suspended project. May face so many different issues. So there might be a certain time. Okay, let's say, can we suspend a project for of 10 years? It is not reasonable, isn't it? It must be a certain time. So during this suspension period, the parties in the contract trying to negotiate and resolve the problem, and they want to restart the project. So if suspension happen, the objective is they want to restart. They are going to resume the work later. So this is all about suspension. Now when come to the termination, now this is story something different now. It is not a temporary action. It is a permanent action, and it is going to be end the contract entirely. It is not going to be resumed. The contract between the party going to be end. Okay, so why termination happened? Okay, we will learn in detail, but some reason for the termination, say breach of contract. Parties in the contract, one of the parties in the contract, okay, breach the contract, or maybe they didn't meet the deadlines of the project, or the parties went to the insolvency or bankruptcy. There may be a lot of reason for this. So therefore, the work on the project will be stopped if the suspension happen, and the parties are released from their contractual obligation for each other. So that is the end of the story. So now you understood the suspension and the termination difference. Okay, if you are clever enough, you can make small table based on the information I have given to you. So now let us go to the subclause 8.8. Okay, what is the page number?
28.
Page number?
28.
Very good.
28.
Okay, all of you go to the page number 28, subclause 8.8. Mark it the way I marked. Okay, so it says engineer may at any time. So engineer may at any time instruct the contractor to suspend the progress of part or all of the works during the suspension. Contractor shall protect, store, and secure contractor shall protect, store, and secure such part or the works against any deterioration or loss or damage. So there's a suspension happen. There's a responsibility for the contract. Okay, you suspend the project, I will go away from the project. Is that contractor just can leave the site? What do you think? No, he has the obligation when suspension happen. What are those obligations? What do you think? What are those obligations?
Protect the existing work.
They have to protect the existing works. Okay, so are they protecting free of charge? Is it not claimable?
No, it is claimable.
It is claimable because it is additional work for them. So they have to claim them. Right, it is not free of charge. So therefore, suspension happen, you have to okay discharge your responsibility. So engineer,
But I believe it's claimable if that is not the contractor fault.
yes, true. If it is a contractor fault and they suspend, then you can't claim. So continuously, the engineer may also notify the cost for the suspension. So this cost he will notify why we are suspending. And to the extent that this cause is notified and the responsibility of the contractor, the following subclause 8.9, 8.10, 8.11 shall not apply. Now, what is that 8.9, 10, 11 shall not apply? 8.9 consequence of suspensions, payment for plant and material in the event of suspension, prolonged suspension. These all are claims. So you can go for this kind of claim if the contractor reason for the suspension. Otherwise, it is a claimable event. Okay. So now do you understand? It is a claimable event. Yes, it is a claimable event. You can claim. Okay. So go to the 8.9 consequences of suspension. Okay. Under this scenario, what is going to happen if the contractor suffers delay and incurs cost? Okay. From complying with the engineer instruction under subclause 8.8 suspension of the work and or from resuming the work the contractor shall give notice to the engineer shall be entitled to the subject to subclause 20.1 contractor claim for an extension of time and payment of any such cost shall be included in the contract price. So after this receiving this notice, the normal procedure will happen. Engineer need to do the determination. So yes, it is very clearly says. Okay, it is very clearly said. Okay, you can claim it if the contractor suffer delay. Okay, so that is very fair, isn't it? Fine. So all of you marked. Have you all marked? Okay, make sure you marked. Okay, so don't leave without marking your fatigue. Okay, now consequence of the suspension. The contractor shall not be entitled to extension of time for and to the payment of cost incurred in making good the consequence of the contractor's faulty design, workmanship, or material, or of the contractor's failure to protect, store, and secure in accordance with the subclause 8.8. So it's very clearly says if the contractor is the one reason for this all, then he can't make this claim. Otherwise, yes, you can claim the suspension. Okay, so it's very clear. Now 8.10, all of you go to the 8.10. payment for plant and material in the event of suspension. So it is very straightforward. The contractor shall be, okay, it says, okay, obligations. The contractor shall be entitled to payment of the value as stated the date of suspension of plant and or material which have not been delivered to the site. So what does that mean? What is this plant and material here? Is the material on site or off site?
Both.
Offsite.
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 It is a off site. Right, it's not a on site. Why it says plant and material which have not been delivered to the site. So that is off site, not on site. Just mark it, okay, everyone. So everyone mark it. So it says the plant, the work on plant or delivery of plant. So it says the work on plant or delivery of plant and or material has been suspended more than 28 days. The contractor has marked the plant and or material as an employer property in accordance with the engineering instruction. Okay, so these things you should understand. You cannot, okay, just claim material offsite. Now they are under the payment. We will discuss about them how to claim the material on site or how to claim the material offsite. Yeah, you will learn them. So for time being, you should understand. Yes, there is a procedure how to claim the material offsite. That all procedures should be followed. Otherwise, as a consultant QS, you can't you can't just claim the material because it is offsite. You have to follow the procedure. So now 8.11, if the suspension under subclause 8.8, under subclause 8.8, suspension of work has continued for more than 84 days. Now we should understand how long we can go for a suspension. Yes or no? Otherwise, it is going to be unlimited time, isn't it? So there should be a limitation. Up to how many days, how many months, or how many years you can suspend a project. So there should be a limitation. Because if the projects are suspended, then there's some reason. Okay. So now here, if the suspension under subclause 8.8 has continued for more than 84 days, okay, it's continued more than 84 days, the contractor may request engineer permission to proceed. So there's a time limit given, right? 84 days. It's more than 84 days. If the engineer does not give the permission within 28 days after being requested to do so, the contractor may, by giving notice to the engineer, treat the suspension as an omission under the clause 13, variation and adjustment of the affected part of the work. If the suspension affect the whole of the work, that means entire project, the contractor may give notice of termination under subclause 16.2, termination by contractor. So look at the seriousness of the days. So how many days it was given? 84 days continuously, right? It's a continuous 84 days, but it is not a final. Different place we will have a different timeline. So we will understand that also. So don't come to a conclusion, okay, 84 days is the maximum days. No. There's another days, that there's a continuously or cumulatively. The both cases are we have to read. So here it says 8.11, okay, continuously the project continued more than 84 days. Ask the engineer to continue the work. If not, treat it as suspension if it is a part of the work. If it is a full project, then you have to consider as omission. So that is going to be termination. So now 8.12, you are ready to the work. You are going to return to the work. Okay, so after the permission or instruction to proceed is given. So okay, there are something. Okay, you have to mark here under the 8.11. Do you all understand the 8.11? Okay, so say this omission to be treated as a variation, right? So you have to. So who is going to issue the instruction for the variation? Who? Who have the rights? Engineer. So engineer must
Contractor.
give the, no, engineer, not contractor. Engineer instruction must come as a variation and adjustment. Okay, this part is omitted. Yes, you are going to confirm. You didn't confirm, therefore I will consider. So, but you have to take the engineer instruction. Let's say engineer don't want to give the omission. He is not responding. Okay, and he is not even ready to give the any instruction as a omission. Then this is going to be treated as a claim. So if not treated as a variation, then it is a claim. Okay, you have to mark it. This you just don't forget to mark it under the 8.11. If it is not treated as a variation, it's going to be a claim. Either way, you have to claim the money, isn't it? Now 8.12, after the permission or instruction to proceed is given, the contractor and the engineer shall, okay, jointly examine the work and the plant and the material affected by the suspension. The contractor shall make good any deterioration or defect or in loss of the works or plant or material which has occurred during the suspension. So deterioration or defect or loss of the works or plant or material which is happened due to the suspension. Okay. So what is that? Contractor shall make good any deterioration. Is it contractor obligation? Yes. So is it free of charge? Is it free of charge? You don't need to claim.
You can claim
It
it.
is, you can claim it. But is there any claim provision given? It is given under the 8.9. Okay, so you have to connect the 8.12 with the 9 because it says if the 8.9 says consequences of the suspension, if the contractor suffers delay and incur cost, so accordingly 8.12 he incurred the cost. You have to prove it. Okay, so next one we have to think about this one. So when the contractor has the right to suspend the work, now we talk about the suspension, right? So when the contractor has the right to suspend the work, now all of you go to the subclause 16.1. That is a page number 49. Yes.
Oh, 49.
Okay. So here it says contractor, okay, has a right to suspend the work and when if the engineer failed to certify in accordance with the subclause 14.6. Yes, it is given. Issuance of the payment certificate is delayed. So engineer failed to certify or the employer failed to comply with the subclause 2.4 employer financial arrangement or It says the employer failed to comply with the subclause 14.7 payment. Okay, so now look, it's all about money, isn't it? Engineer failed to certify, payment not done. Employer failed to comply, employer financial arrangement. Contractor suspected whether employer has the money or not. Employer failed to comply with the subclause 14.7 payment. That means he didn't pay. So do you understand? When it's very crystal clear when the contractor can suspend the work when he didn't receive the payment. Do you understand? Yes. So no money, no works. That's it. So now we'll go back to the 16.1 and trying to understand. So this is a snapshot for you. Okay, same thing we are going to discuss here under the 16.1. So if the engineer failed to certify in accordance with the subclause 14.6, issue of interim payment certificate, or the employer failed to comply with the subclause 2.4, employer's financial arrangement, or subclause 14.47, okay, payment, the contractor may not less than 21 days notice to the employer suspend or reduce the rate of the work unless until the contractor has received the payment certificate or reasonable evidence of payment as the case may be and as described in the notice. Okay, so 21 days notice is needed, isn't it? Can you suspend the work without giving the notice? You cannot. You need to give the notice. You have to give the notice to suspend. Okay, so it's continue. The contractor action shall not prejudice his entitlement to financing charges under subclause 14.8. Say if it's a delay payment happen, there will be a financing charges. And to termination under subclause 16.2. Okay. So do you understand there is a financing charges. Now regarding the subclause 14.6, 2.4 and the 14.7 we will discuss, and also subclause 14.8 we will discuss. But do you understand all about this? If no money, you have right to suspend. Okay. Okay. Similarly, you can't just suspend without giving the notice. Just be careful with that. Don't go to the suspension or termination unless otherwise you take the proper legal advice. It's not an easy task when it is come to a real practice, isn't it? Therefore, take a proper precaution. So continuously the subclause 16.1 says if the contractor subsequently receives such a payment certificate or evidence or payment as described in the relevant subclause and in the above notice, before giving a notice of termination, contractor shall resume normal working as soon as reasonably practicable. Okay, so he can continue the work if that problem is resolved. Okay, it says if the contractor suffers delay and incur the cost as a result of suspending the work or reducing the rate of work in accordance with the subclause, the contractor shall give notice to the engineer and shall be entitled to subclause 20.1. There he can claim extension of time. Okay, then cost plus profit. Cost plus profit. Okay. So all of you go to the 8.9. Are you there on the 8.9? Subclause 8.9. Okay. Let's do a comparison. Now, if the suspension happen, answer me carefully, okay? If the suspension happen, the reason for the suspension is not the contractor. It is because of the employer fault, let's say. Does the contractor has the right to claim? Yes or no?
Yes.
Yes. Okay. So 8.9, what did it says? It says time. 16.1 also it says time. What about the B? 8.9B. It says cost. But 16.1B say cost plus reasonable profit. You understand? So cost plus reasonable profit. Now, if you are a clever contractor, suspension happened because of the payment delay and you suspended the work. Which subclause you will prefer to use, 8.9 or 16.1 to make the claim?
For sure, 16.1.
Why?
Because there is a profit there. Capital C in FIDIC, it's without profit. So 8.9 will be only the actual cost incurred. But for 16.1, you will be claiming your overhead and profit as well.
Correct. So just mark it. Okay. Just mark it next to the 8.9. Okay. According to the 16.1, you can add the profit also. So it's like a better practice for you. Yes.
Us,
So,
that depends on the situation, right?
yeah. I'm talking about the payment delay you suspended. So don't use the
Yeah,
8.9. Use the
but
16.1.
still, it has. يعني, if the suspension is coming from the contractor or the contractor who initiated the suspension, then we can apply 16.1. But if the employer himself imposed the suspension, then we don't have any chance to apply 16.1. Am I right?
Correct. Yes. 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 If the as a different reason, it's not about the payment, then yes, you can apply this one. Okay. So now some terms relevant to the suspension we are going to discuss today. So let's go to the 7.7 page number. Everybody go to the 7.7. It says each item of the plant and material sale to the extent consistent with the laws of country become the property of the employer at whichever is the earlier of the following item free from lands and other encumbrances. So when it is delivered to the site, when the contractor is entitled to the payment of the value of the plant and the material under subclause 8.10, payment for plant and material in the event of the suspension. So do you understand? It is connected. So again, now previously we talk about the material on site. Sorry, payment for the plant and material, right? Which is off site. Now, what is this material? On site? The 8.10 talk about the 8.10 talk about the off site. So the B talk about what? B talk about the off site. A talk about what?
On site.
On site. Can you mark it? So 7.7 A is on site, B is off site. So you got a both chance to claim both of them. So finally, it will be very helpful for you to learn. Okay, so just mark it. According to the 7.7, 8.10, you got only one chance. Okay, you can go for offside. But now 7.7 very clearly say you can get the A also. Okay. Now let's go to the 11.3. Employer shall be entitled subject to subclause 2.5 employer claim to an extension of the defect notification period for the work or section if and to the extent that the works or section or major item of plan, as the case may be, and after taking over cannot be used for the purposes for which they are intended by reason of a defect or damage. However, defect notification period shall not be extended by more than 2 years. Probably any project they have a defect notification period. Yes or no? Yes, they have the defect notification period. So, what is defect notification period in your project? Everyone have it now. So, what is the defect notification period? 400 days. Okay, different answer. Near, maybe sometimes 6 months. Yeah, depends. It is depend. So, what this FIDIC says, whatever it is, you can't extend the defect notification period more than 2 years. Sometimes defect notification period could be extended due to so many reasons. Say defects are not rectified during the notification period, during the DNP period. That means you can extend. So if delivery and the erection of plant and or material was suspended under subclause 8.8, suspension of work, or subclause 16.1, contractor's entitlement to suspend the work, the contractor obligation under this clause shall not apply to any defects or damage occurring more than 2 years after the defect notification period for the plant and or material would otherwise have expired. Okay, so if what is this says? Okay, it is connecting to the suspension now. If delivery and the erection of a plant or material was suspended under subclause 8.8, okay, the contractor obligation under this subclause shall not to apply to any defects or damage occurring more than 2 years after the defect notification period. Okay, so that's a limitation given here. The limitation is if that particular things or works or element impacted because of the suspension, okay, then it's already there is a prolongation happen, isn't it? There's a delay happen. Now think about the scenario. Project started. 1 year you went through the project. It's a high-rise building. Let's say about the 10-story building. So fifth floors are completed. Then you suspend the project. So let's say suspension went for a 1 year. Assume, okay. What do you think? All the materials or whatever the work you have done to that building so far after 1 year, don't you see any defects on that one? Or what about the material stored at site? Don't you see any defects? Right? So this subclause simply say, don't penalize the contractor if that the case, because of the suspension anything happened, don't penalize the contractor more than the 2 years because it is already impacted. Do you all understand what I'm saying here? Okay, good. So there's a limitation under this.
Uh,
14.2.
uh, Excuse me.
Yes.
I got one question. Like this suspension, it like some work which is already suspended, and after the completion of the project, and that suspension time can be considered as a defect liability or somewhere because that is like already old one may have the defects
No, no,
later on.
no. Defect liability period. That means defect notification will start once the taking over certificate given. So you can't
Okay,
consider that period to this period.
okay, okay. So it's totally separate, huh?
Yeah. You can't
Oh,
join that.
okay, okay, okay,
You
okay,
got the
okay.
provision to claim for a losses or damage, anything happen, even the extension of time.
Mm-hmm.
Yeah.
Okay, I understand now. Thank you, thank you.
Yes. So all of you go to the 14.2 page number 41. Okay. If the advance payment has not been repaid prior to the issuance of the taking over certificate for the works or prior to the termination under the subclause termination by subclause 15 termination by the employer or clause 16 suspension and termination by the contractor or clause 19 force majeure as the case may be, the whole of the balance then outstanding shall immediately become due and payable by the contractor to the employer. Okay, so do you understand now? This is all about the advance payment. That not paid, if suspension happen or termination happen, if it is not, you didn't pay the advance payment back to the employer, you have to pay all of them. Okay, so it's very clear the that you remember we discussed about this advance payment under the advance payment guarantee. There also you can connect. Okay, this subclause already we discussed. Just to refresh you because it is connected again with the suspension. Now 15.2 termination by the employer. Okay, just mark it here under the 14.2. You know this paragraph at the last of the 14.2, right? You know this paragraph under the 14.2, yes or no? Yeah, mark to that. Immediate situation to recover is a advance payment. It's an immediate situation where employer can recover the advance payment given to the contractor. This is shall immediately become due and payable. You have to mark if you want. Shall immediately become due and payable. So that is the situation. Just mark it. Then all of you go to the 15.2. Okay, so 15.2. Okay, let's see. What's the page number?
47.
47. Very good. This is very important subclause. You should not misunderstand. Many people misunderstand this subclause. Employer shall be entitled to terminate the contract if the contractor, okay, if the contractor without reasonable excuse okay, fail to proceed the works in accordance with the subclause 8, commencement, delay, and suspension. Okay, so now you understand it says about suspension. The employer shall be entitled to terminate the contract if the contractor, okay, C, subclause C, without reasonable excuse, fail to proceed with the work in accordance with the subclause 8, commencement, delay, and suspension. That means, okay, commencement delay, or he didn't resume the work after suspension closed. But the 15.1 is a very misunderstood, understandable clause. Do you have any note for a 15.1 before? Any one of you? Did you have marked or take a note on the 15.1? No. Okay. You should understand when to apply this 15.2. So all of you read the 15.1. Notice to correct. We will discuss the 15.1 under the termination also. But just let's understand now. Okay. If the contractor failed to carry out any obligation under the contract, that means what it says, If the contractor failed to carry out any obligation under the contract, and the engineer may by notice regard to the contractor to make a good the failure and remedy it within a specified reasonable time. So the engineer may by may by notice regard to the contractor. That means engineer if the contractor failed to carry out any obligation, and that means contractor responsibility. The contractor says he didn't do any of the responsibility, so engineer can issue instruction notice to the contractor to do the work within the specified reasonable time. No, I didn't move the slide. I just sticking with the 15.2 and explaining the 15.1. So do you everybody understand? Yes. So try to understand the 15.1. Now let's say, are you going to apply the 15.1? Let's say contractor, everybody carefully observe. Okay. Now contractor need to do some works. He didn't come and do the work. Contractor need to do the work, but contractor didn't come and do that work. Now engineer asking, please do this work. So can we take this 15.1 to that scenario? Contractor supposed to come and do the work, where the contractor didn't come and do the work. So according to the pursuant to 15.1, notice to correct. Can we do that letter by notice 15.1? Yes, this is what your everybody answer. No, yes, but answer is no. Don't use that one. This is not the place you will use this 15.1, because remember there are so many other subclauses available to rectify the mistakes. There are so many other subclauses. If there's any default or defective, you have so many subclauses within the FIDIC. Using those subclauses, you can rectify. But don't use the 15.1. What is the 15.1? If you are sending the 15.1, it is the scenario I am going to explain you. You send the notice based on the previous subclauses, different subclauses. He didn't listen you. You send again the warning. He didn't listen. You send again instruction. He didn't listen. Now you are sending 15.1. Look, Mr. Contractor, you have this problem. You have to rectify within this time. What do you mean by 15.1? If he not follow, 15.2 will become next. That's a termination. You understand? You send a notice by other subclauses to rectify, that is not a problem. But actually the 15.1 kind of a thunder attack. Because next subclause will be followed. What is that? 15.2. So don't use the 15.1 for a simple problem. It is a ultimate, okay, note down under the 15.1. It is a ultimate option before termination. Note down that wording. Okay. Should not use in a general purpose. Can you note down that one? So don't use the subclause for a general purpose. It is ultimate subclause before termination happen. So somebody, if you are a strong contract person, if the engineer sending 15.1 notice to correct, that means next will be a termination if you don't follow. So they are giving additional time again. Okay, so if you see the 15.2a failed to comply with the 4.2 performance security or with the notice under subclause 15.1 notice to correct. Do you understand now the strength of this 15.1? So it is not the normal subclause. Okay, many people don't understand what is the subclause standing for. Basic issues they will issue the 15.1. If you not comply, then they are going to send the 15.2a. Do you understand what I am saying here? just rectify. Okay, many of you say yes, you are going to use this subclause, so don't. Okay, have you all note down? Shall we go to the 16.2? Confirm if you want, take your time to note down.
Sir, I have a question. For 15.1, is there any time for the contractor to rectify
That was
and
said, no? Within a specified reasonable time. That means they will mention the timeline. There's no timeline given, 7 day or 21 days. Because of the scenario, we don't know why they are sending this notice. So they will give a reasonable time.
okay?
Yeah, that's what they say, reasonable time. But that reasonable time is a suspicious wording. Okay, the contractor say no, this is not a reasonable time. So how to prove this is a reasonable time or not reasonable time? That's going to be another dispute. Okay, you got it, no? So let's go to the 16.2. Termination by the contractor. The contractor shall be entitled to terminate the contract if a prolonged suspension affect the whole of the works as described subclause 8.11. So we learn about 8.11, isn't it? So just mark it. Okay, so some practice question for you. You have to do this homework. And if you send the answer, I will send you. If you send the answer, I will send you the answer. If you don't send, I will not also not send, because as long as you practice only, you are going to develop. So under what circumstance can engineer instruct the contractor to suspend the work? What entitlement does the contractor have if they suffer delay or incur cost due to the suspension? Two subclause talk about it, isn't it? When is the contractor entitled to payment for plant and material in the event of suspension? Two subclause talk about it. What action can the contractor take if suspension continue more than 84 days? One subclause talk about it. Can the employer terminate the contract if the contractor failed to proceed with the work without reasonable excuse according to subclause 15.2? What trigger the contractor right to terminate the contract under 16.2? What is it? What's the key wording? 16.2. What is that?
Prolonged suspension.
Prolonged suspension.
16.2. Okay, fine. Mostly about the money. Okay. Anyway, you have so many points inside. What action must the contractor take during the suspension of work according to subclause 8.8? What he should do? You know the answer already. What limitation exists in the extension of defect notification period as per subclause 11.3? You know the answer. Now you learned, you answer it. You have the answer for all of them. So you can compare once you send the file, do it in the Word document, send the file, I will send you my file. So it's
Mr.
homework.
Munaf, I have one question, please.
Yeah.
Yeah, for subclause 11.3, we said that the contractor obligations under that clause will not be for any defect or damages occur more than 2 years for the material or plant, will not be applicable, correct? For more than 2 years from the DLP.
Yeah, if it is an impacted item due to suspension.
Yeah, so let's put this scenario during the project. The project
Hmm.
start in 1st January and will complete it in 1st December as example. Okay,
Wait,
so
let's go to the 11.3.
yeah,
Okay, 11.3. Okay, go ahead.
yeah. So if the project starts by 1st January and will be completed by 1st December, and suddenly on May the project suspended for 1 year as example, correct?
Okay.
Now there were plants and there were equipments and materials at that site. So mostly that warranty or whatever on the material will be after the delivery. Now
Yes, yes.
the contract saying from the TOC we need the warranty. We can extend it. This is not a big deal. But once a suspension occurred, if I couldn't
Hmm.
extend the warranty, now let's put two situations. In the normal scenario, you will take the TOC, then DLP, and there is 2 years shall not be extended that, correct?
Yeah.
But if
Okay.
you
So
could not
now your question regarding the warranty or what?
No, no. My question is regarding that material. So if this suspended for 1 year, and after the 1 year we got the TOC and the LB started, can we say that this contractor obligation will be 1 year in the DLP only, because 1 year plus 1 year suspended, or no?
Yeah, if I understand the clearly, you are talking about the warranty period claims.
No, not
Okay,
warranty. I'm talking about our obligations, correct? That clause
that's what
saying,
you have to have the warranty after handing over the project, right? So due to the suspension, the warranty is expired. Is that
uh, okay, let's go like that.
okay? There are some scenario happen. I will share my experience. Okay, there was a project delayed, not suspended. Same scenario, but delayed. Okay, more than 5 years. So like a major equipment, they have the warranty for a 10 years. Sometime you might be aware about that
Mm,
equipment plant. So what was the claim? The one claim, okay, the employer paid for extension of the warranties. So when it is expired, you are going to keep on, um, you know, you have to extend it.
yeah, and for all cases, once that project is suspended, this 1 year suspension, you cannot
Hmm.
deduct it from the 2 years after the LB, correct?
Yes,
You
because
should.
you can't penalize something impact because you have given to the contractor. That's
uh,
what it is very reasonable subclause.
so whatever it is, the LP period expired, you have 2 years obligations, correct? Whatever suspension happened, 5 years, 6 years, 10 years, whatever it is, correct?
Yeah. Let's say now all the material don't have the 2 years warranty. You know that one. Sometimes it will be
Yes.
have only 1 year. Then if
Yeah,
they
yeah.
agree only 1 year warranty, if it is mentioned anywhere in the pricing preamble or anywhere in the pricing document or contract,
Hmm,
then his obligation will be end with the particular period.
correct.
Let's say 1 year, he's 6 month delay happen. So
Hmm,
once the taking over certificate given, he must give the 1 year warranty for some
yes.
item. Now already 6 months suspension happened. This item already installed before the suspension happened. Now you can't ask this 1 year warranty because 6 months only remaining. 6 months already gone.
Yeah, he
Okay.
should pay for
If
the
you
other
want,
6 months.
yeah. If you want to have additional 6 months, then you have to pay for that. That's the things.
Yeah. But in the normal situation, if it is not warranty or something, only material and plant, we have to wait DLP, then 2 years, then the obligations will stop, correct?
Yes.
Okay,
Anyway,
thank you.
it's all about extension of the defect notification period. Say sometime you are going to go for a DL defect notification period is generally 1 year. Let's say
Yes.
during the defect notification period, contractor due to some other fault he didn't finish the works. There was a snag list when you are issuing the taking over certificate. He didn't finish the work. Okay, so because of that reason, this other item which is not part of this particular damage or defects, but that part of the item which is part of the uh, what we can say the suspension, then that part only we are talking here.
Mm.
Yes,
Yeah, I have one question. Hello?
go ahead. Yeah.
Yeah, if defect notification period is 2 years, okay,
Hmm.
and some of material like sports flooring or artificial grass in the like, and we have warranty more than 5 years or 10 years, like swimming pool tiles, rubber flooring. So in this case, we can tell, okay, our DNP is finished 2 years, and this warranty or guarantee we cannot do. How it will work?
No, no, no. It's like if some equipment or plan you can go up to 10 years. So you can't say this particular subclause for that purpose.
So this clause for what? Overall contract?
This talk
Or,
about the suspension and its impact because of the suspension. That particular item impact because of the defect notification period also got extended. Okay, that scenario only we are talking. We are not talking the general warranties. Okay.
okay.
say your case, swimming pool. So let's talk about the air handling unit of the air conditioning system. So some heavy equipment that used in the project. Generally, it have the 10 years warranty. Okay. Now that 10 years warranty got impacted by the extended defect notification period. But anyhow, taking over certificate is given. You have the warranty starting from there, if that the case. Okay. But let's say you install the item before the suspension happen, which is happened during before the taking over certificate issuance. So already you have taken some time, isn't it? Yeah. So that time should be compensable. So that is one case. Second case, you can't whatever the reason, you can't extend the defect notification period according to this subclause more than 2 years. Let's assume this scenario. Okay, one particular works at the project, not as per the contractual requirement. It's a defective works. Contractor keep on doing up to 2 years. Nothing happen. No approval happen. Now what do you do at the last? Defect notification cannot be extended more than 2 years. Now you come to the end of the day. So what you can do? Do you have any idea?
We have to
You
fulfill
mean
the
you have
requirements.
you mean there are balance works or what?
Even it is the last day, we have to rectify it and correct it.
No, that in that scenario, there's a subclause, okay, in the FIDIC. That work not going to be paid to you. It will be reject, and you have to compensate the employer for all the losses happen. That is a scenario. You can't go more than 2 years. If you can't do within 2 years, you can't do more than 2 years. So there should be an end. There should be a full stop. That part of the work will going to be paid back to the employer. So it's going to be employer client. Do you understand now?
You
Okay,
you
let's
you
go to
mean
the.
to say that
Yeah, yeah,
if you don't rectify within 2 years, then the whatever the balance rectification cost to be given to the client, correct?
Yeah, if that particular item not meet the fit for the purpose, yes, you have to. There's a one particular subclause mentioning about that one. You understand? Everybody clear?
yes, clear.
Okay. Okay, let's move on to the termination.
So excuse me.
Yeah.
So I have a small doubt. You said we should not use the 15.1 for general purposes because the 15.1 will trigger the 15.2. I have a small
Yes.
doubt. Is it engineer obligated to go for 15.2 if the 15.1 is triggered? He's always obligated, or he can say, no, I'm not going for the 15.2, and they can find a way to resolve the issue.
You can't just terminate the contractor without proper notice, right? Yes or no? So, if you want to give the room for the improvement, or if you want to give chance to okay, get the job done, then use the 15.1. Do you understand?
Sorry, sir, I don't get it.
Simple. Don't use the 15.1 unless otherwise you have intended to go for a termination. And if the 15.1 also given, there's a specified time given to rectify the damage. If it's not meet only, then you are going for a termination. And before you go for a termination, you must take the legal advice. Do you understand? Uh, don't instruct or advise anyone to go for a termination or suspension without take the legal advice. It's a big problem.
Okay.
Take a legal advice before you do something like this. But you must have the full idea about the contract. Okay, but there every jurisdiction they has a procedure. Now, if you want to go for a termination, you can't just do the termination without court order in some countries. Do you know that one? It is not in the contract. If you want to terminate, you have to take the court order. Yes, now let's go to the term about the termination. So now I have one question, everybody. Terminate the works or terminate the contract? Which one is the correct one if you want to terminate the project?
Contract.
Terminate the contract.
Contract.
Yes.
Okay.
We
Terminate
terminate
is
the.
part of the
I'm
contract.
I'm not sure. We terminate the work, suppose the particular works, and due to some other people, due to his less performance, terminate the work, some part of the work.
Okay, let's understand. Okay, just listen, everybody. Now I ask which term is the right term? Which term is appropriate to terminate the contractor, right? So you say terminate, some people say A, some people say B, some people say both. Okay, let us understand now this terminology. Terminate the work, terminate the contract. You should understand this wording carefully. They are not a similar meaning. This is not a similar meaning. They have varieties. Now, legally, both, okay, terminate the works, terminate the contracts are correct legal term. There's no wrong. But they have a different meaning and you have to use them in the right situation. Now let us understand what is a terminate the work. Okay, generally, okay, this is particular wording refer to ending the particular project or task. For example, okay, employee might say, we need to terminate the work on this project due to budget problem. That means he don't want to continue. He's terminating the work. He don't want to continue. That is our meaning of terminate the work. Now let's say terminate the contract. This is typically referred to ending the legal agreement between the two or more parties. Say, for example, employer might terminate the contract with the one contractor. But if the contractor is not fulfilling the contractual obligation, he will go with another contractor. So in that case, you can't use the terminate the work. If you want to continue with another contractor, you will terminate the contract with the particular contractor, go with another contract with a different or new contractor. That is terminate the contract. So which term to be used depend on the content where you are going to apply. Okay. If you are referring to end the project, no longer you are going to continue the project, you are going to abandon the project, then terminate the work is appropriate. If you are referring to end the legal agreement with the particular contractor, then terminate the contract is a correct term. Now answer the question. If you want to terminate the contractor, A or B?
B.
Every one of you. B, yes. But if you don't want to continue the project here no longer, then what is the right term?
Terminate the work.
Terminate the work, yes. Correct. Okay. So now let's go to the 16.2. When the contractor has the right to terminate the contract. What's the page number? 49. Yeah. Okay. So let's refer 16.2. Just keep everyone mic mute, please. Okay. So let's refer 16.2. Termination by the contractor. So the contractor shall be entitled to terminate the contract. It's a contractor rights to terminate the contract if the contractor does not receive the evidence, reasonable evidence within 42 days after giving notice under 16.1. Contractor entitled to suspend the work in respect of failure to comply with the subclause employer financial arrangement. What is this ultimately? What about this? A, money, isn't it? Okay. Second, B, engineer failed to, okay, certify the payment certificate within 56 days. Again, what? Is the money. Third one, the contractor does not receive the amount due under the interim payment certificate within 42 days. Okay, so again, it is about what? Up to now, it's all about money. Okay. Or D, the employer substantially failed to perform his obligation under the contract. Now something breach of contract. Okay. Whatever the engineer sell, whatever the employer sell, is the employer obligation. He didn't perform, and you are giving the room for a contractor to terminate the contract. The employer failed to comply with the subclause 1.6 contract agreement or subclause assignment. So again, 1.6 contract agreement or subclause 1.7 assignment. Okay. A prolonged suspension affect the whole of the works as described in subclause 8.11. Now, yes, you have suspended the project, every part of the work, whole of the work, and after 84 days, contractor asks for engineer permission to proceed. Nothing happened, then he can consider as a termination. So that is the 8.11. The employee become bankrupt or insolvent, goes into liquidation or administration order. Again, he don't have money. So G also part of the money. Okay, so the contractor can terminate. Okay, so now what it says, in any of these event or circumstance, the contractor may, upon giving 14 days notice to the employer, less than days, how many? 14 days notice to the employer, terminate the contract. But however, look at this word, terminate the contract. It's the right wording, isn't it? You say terminate the work? No, right? We can't say the terminate the work. So you should understand one wording can change the meaning. So, however, in the case of subparagraph F and G, what is F and G? Prolonged suspension or employee become bankrupt. Prolonged suspension and employee become bankrupt. The contractor may notice, may by notice terminate the contract immediately. So, do you know what are the circumstances contractor can terminate the contract immediately without even the 14 days notice? The subclause 16.2 F and G. The contractor's election to terminate the contract shall not prejudice any other rights of the contractor under the contract or otherwise. So yes, you have to pay all the amount, even he is terminating the contract. Okay. So you might encounter this wording called prejudice. What do you mean by this word? Anyone know?
Without giving
Any?
partiality.
No. Harm. Okay. The terminate the contract shall not harm or make any damage. Okay. The contractor. So it's something about harm or injury that result or may result from some action or judgment. It's a legal term, okay? Just be careful with this. So 16.3. Now do you all understand? Yeah, 16.2 very clearly say 14 days notice, except the two scenario, prolonged suspension and employee become financially in bankruptcy or insolvent or administration process. Okay. Now 16.3. Cessation of work and removal of contractor equipment. So after notice of termination under subclause 15.5, employer entitlement to terminate, or subclause 16.2, termination by the contractor. Oh, there is a one subclause 19.6, optional termination, payment and release has taken effect. The contractor shall promptly cease all the works. means he's all further work. That means he need to stop the work. Okay, except for the works as may have been instructed by the engineer for the protection of life or property or for the safety of the works. So he need to stop the work if you are terminated the contract. Hand over the contractor document, plan, material, and other work for which the contractor has received the payment. Okay. Remove all other goods from the site, except as necessary for safety, and leave the site. So you understand, no? Once the contract has been terminated by either party, what is the contractor obligation? Under the 16.3, there are three obligations given, isn't it? Okay. Okay. So when the employer has right to terminate the contract, 15.2. All of you go to the 15.2. Now we know what is the 15.1. Okay. So employer shall be entitled to terminate the contract. Okay. Employer shall be entitled to terminate the contract if the contractor, number one, okay, fail to provide the performance security pursuant to 4.2, or abandon the work, failure to comply with the notice to correct. Okay. 15.1, abandon, that means he just leave the project, or demonstration of intention not to proceed, he don't want to continue the work, or the C says without reasonable excuse. Okay. Any reason is he can do something, but without any reasonable excuse to proceed with the works in accordance with the clause 8 commencement or delay and suspension. He didn't commence the work, or he's keep on delaying or suspend the work. Okay, so you should understand you can't do that one. Whatever the scenario, yes, you have to follow. To comply with the notice issued under subclause 7.5, rejection, or subclause 7.6, remedial work within 28 days after receiving. Okay. So 7.5 and 7.6, rejection and the remedial work within 28 days after receiving it. So there are some reason I told you. You don't need to send the 15.1 if there's any problem because of the works are not according to the contract. You can use some other subclauses. Okay. So failure to proceed with the work without reasonable excuse, or failure to comply without reasonable excuse with the notice issued under subclause 7.5, rejection, or subclause 7.6, remedial works, or okay, subcontract. Okay, you can read the all subclauses down. Okay, subcontract all the works, which is D, or assignment of the contract without the regard agreement, or G, sorry, E, become bankrupt or insolvent, or goes into liquidation, or F, they are trying to give bribes or other unlawful inducement. Okay, so now what it says, in any of these events, okay, if you read down, okay, you have the subclause, yeah, right, you are reading. In any of these events, the employer may, on opinion, 14 days notice to the contractor, expel from the site. He is kicking out from the site. But let's see, you remember the termination by the contractor? There are two scenarios, okay? The prolonged suspension or bankruptcy. Same way, in case of bankruptcy or bribery to the employer team, they can do the termination immediately. The contractor shall leave the site having delivered any regard goods, contractor document, etc. to the engineer. The employer may then complete the works or engage others to do so on his behalf. An employer may sell item to recover the debit or whatever the payment due by the contractor to the employer, okay, which is subject to the law. This is kind of a very big subclause. Okay, so you understood the consequences. Now all of you go to the subclause 4.4. The contractor. Now we talk about something about subcontracting, isn't it? So all of you go to the subclause 4.4. What is the page number?
14.
Contractor shall not subcontract whole of the work. What I mean? Okay, it doesn't say you can't do the subcontracting. You can do subcontracting, but there should be a percentage, isn't it? There should be a limitation. So you can't go beyond that. If you go beyond that, then you are doing something wrong. So the contractor shall not subcontract whole of the works. Now, if you all go to the subclause 15.2d that we all just now referred, the employer shall be entitled to terminate the contract if the contractor D subcontract whole of the work or assign the contract without the regard agreement. With whom? Employer. So the contractor shall be responsible. The same subclause, okay, 4.4. The contractor shall be responsible for the act or defaults of any subcontractor, his agent or employees, as if they were the act or default of the contractor, unless otherwise stated in the particular condition. A. The contractor shall not be required to obtain the consent to supplier of material or to subcontract for which the subcontractor is named in the contract. Now, look, I think we have learned the subclause under the subcontractor. Otherwise, you will learn the subclause again under the subcontractor. Okay. Let's stick with this particular idea. Now you can't do the subcontracting. Okay, for all the project works, you have to take the permission. Without permission, you can't do. So please just keep the mic mute unless otherwise you are going to ask the question. Okay, so that is the reason. Now I will skip this subclause. I believe you have marked already. Am I correct? Most of you. If not, this subclause, okay, will be come under the subcontractor. So no need to repeat. But time being, you should have the note that yes, you can do the subcontracting with entire project. Okay. Now 15.2. Yes.
Yeah, this subcontractor, it will be either nominated or domestic, it will be both.
It will be a domestic only. If it is a
Only domestic.
nominated, then yeah, see, the employer don't do every works by the nominated, right? Only particular work they do. If they want to do every works by the particular nominated one, then why they need the main contractor? They can go with
Yeah.
the same agreement with the subcontractor, no, which is nominated. So no, it's not that one. It is all domestic.
So the contractor responsible only for domestic subcontract.
We will discuss about the subcontracting and other subcontracting. Have you done that particular lecture series?
Yeah.
I don't think so. Okay, then they are covered. Contractor responsible for all the parties, but there's a limitation on the responsibility.
Okay, thank you.
Let's say very simple. Okay, if you want to recall, the contractor delay the works. Let's say subcontractor delay the works. Either he is a domestic or nominated. Contractor is responsible. But when the domestic subcontractor delay the work, or if the employer don't want to continue with this particular domestic contractor, then replacing them, bringing the new contractor, any delay caused by or any cost incurred by that particular action, become the employer claim against the contractor. Other way around, nominated subcontractor delay the works, and the contractor says, employer, I don't want to continue with this particular nominated subcontractor, bringing the another nominated subcontractor, and delay happened due to that action, and any cost incurred due to that action, it has become a contractor claim against the employer. These particular things we discuss under the subcontractors lecture series. I think you can recall them again. Okay. Now 15.2, become bankrupt or insolvent, goes into liquidation, has a receiving or administration order. Okay, this, we discussed this subclause. So yes, you have to very careful when you go for a termination or suspension. Keep it in mind. Learning very depth about this all the subclauses, but you have the strong knowledge to justify what to do next. But when come to this particular scenario, you must take the legal advice. You don't implement by yourself. Okay, you don't do that one. Okay, so this will we discussed already. I just put the sub clauses. Okay, so let's go to the 15.5. 48, isn't it? Okay, so if you read there, the employer shall be entitled to terminate the contract at any time, for the employer convenience. See that reason, okay? What it says? It is his convenience. By giving notice of such termination to the contractor, the termination shall take effect 28 days the later of the date on which the contractor received the notice or employer returned the performance security. Remember somebody, we talk about the subclause under performance bond. Yes, you might already mark this one. Am
Yes,
I right?
yes.
I think,
Under
yeah,
performance
somebody,
security.
some people noted that, and you will recover this one. So again, see, you have 28 days, but return the performance security. Okay, so now there's a one question came. Okay, if you are giving the notice under 15.5, 28 days. What about if you return the performance security? There's no days provision given, isn't it? Okay. So now let us understand this particular sub paragraph. Okay. The employer shall be entitled to terminate the contract anytime because of his convenience. Okay, but it says the after this termination, contractor shall proceed with the accordance with the 16.3. Okay, you have to cessation of the work and removal of the contractor equipment and shall be paid in accordance with the subclause 19.6 optional termination payment and release. Now look at this first paragraph. The employer shall not terminate the contract under this subclause in order to execute the work himself or to arrange for the works to be executed by another contractor. Now it's very clearly say, you can't just terminate the main contractor because you want to continue with another contract. What do you think the bespoke contract? Do you think the employer prefer to do keep this kind of subclause?
Impossible. One line only. Terminate for
Yes,
convenience at any time.
exactly. So they will remove the second, maybe they will, okay, this particular sentence, okay, not acceptable. So remove. They will put the comment, put the double bracket and remove this one. That's all possible. Okay, so
They will,
just be mindful.
they will add the contractor is not entitled for loss of profit or whatever.
Yes, but anyhow, the contractor has the right to claim some losses because there is a Sharia law, good faith and fair deal. So therefore, still the
That's correct,
employer
but
will
you
be
know, no
trouble.
one will take the decision to go for court.
Yes.
Rarely.
Why? Yeah. Why? Because if they go for a court, then it will be very public, and they will not get the project from the other employers, relatives, or even the
And it
same employer will not give
will
any other
take years.
project. Okay. Now, predict terms related to the termination. We'll see what are the terms are relevant to the termination. All of you go to the 11.4, failure to remedy the defects. Okay. If the contractor failed to remedy any defects or damage, so if the contractor failed to remedy any defects or damage within a reasonable time, a date may be fixed by on behalf of the employer or or before the defect or damage to be remedied. The contractor shall be given the reasonable notice of this date. So do you understand? I said don't use the 15.1. There are 11.4 talk about the notice. Okay. So 15.1 ultimate to termination. If you are sending 15.1, other side is a good sensible contractor, contract manager. He knows it's a thunder attack for them. It's not going to be fun for them. If the contractor failed to remedy the defect or damage by this notified date, this remedial work was to be executed at the cost of the contractor under subclause 11.2 cost of remedying defects. The employer may be at his opinion, that means option, carry out the work himself or by other in a reasonable manner. Okay, that is one. Then he can claim under the subclause 2.5. That is one. Or regard the engineer to agree or determine the reasonable reduction in the contract price. That means he can deduct some amount from the contractor. Or if the defect or damage deprives the employer of substantially the whole benefit of the works or any major part of the work, terminate the contract as a whole, or in respect of such major part which cannot be put to be in the intended use without prejudice to any other rights under the contract or otherwise, the employer shall then be entitled to recover all sum paid for the works or such part as the case may be, plus financing cost and the cost of dismantling the same, clearing the site and returning the plan and material to the contractor. Do you understand something we talk about the extended defect notification period? Where I say there is a certain limitation, it is past and still the damage is not rectified. Yes or no? Okay. 11.4 C is the answer for that one. Do you all remember what we discussed few minutes before? I said there's a provision in the contract. You have to pay all the money. And this is up close for that one. So note down if you want. Because some people ask that question. 11.4 C. Note down everybody, these are the things. Okay, so we talk about extended defect notification period. Let's say within that period nothing happened, still the damage is damage, defect is defect, then you can, so in that case you can't terminate because the contract is finished, it's on the end of the time. So what you can do, you can recover all the cost. Okay, that is 11.4 and 16.3. After a notice of termination under the 15.5, employer entitlement to termination, subclause 16.2, termination by the contractor, or subclause 19.6, termination. Okay, so we will study this later part of the lecture, which is subclause 19.6, uh, optional termination, payment and release. So now let us understand what is 16.3 says. After the notice of termination, contractor shall promptly cease all the work, hand over the document, remove the all the goods from the site. So we discussed this particular subclause. So you just, I remember, you mark this one. Okay, so now what is that? Okay, so let's do some practice here. Okay, so I put the question here. I have the answer for this one. So if you give the answer, I will give. So under which circumstance the contractor entitled to terminate the contract? So you just practice this one, and next class we will continue with the force major. So before the next class, if you all can give me the answer, is good. So I will say are the my answer to you, so you can practice. So what is this?
Miss,
Under which circumstance the
uh,
contractor entitled to terminate the contract? Yeah, go ahead.
ca- can we talk about the extended class, please? The additional classes.
We will be having the extra classes probably, as you all agree, 2 classes per month on the middle of the week. So maybe we will have it on 15 and 22. Everybody okay with that? On 15 and 22, I will inform you all what is the subject. Probably we don't do the first contract, it's going to be a pre-contract. So don't miss.
Okay, sir, agree.
What about the class that we have missed? The types of contracts. We did not continue this.
Type of contract, I believe you already have the recording because Mr. Mirsan said to you, go through and you can come back with the question you have. Maybe I will clarify. If that only one person have the same issue, okay, then I will talk to you personally. Otherwise, if many of you having the problem, then we can agree a day to discuss. Or maybe in the upcoming days, maybe I can, but I have put the recently one webinar. I think I have the recording. I can give it to you. But in case you are talking about the lecture two, right? That is not yet done, if I am correct.
Yeah.
Yeah,
Yes.
okay. We can do that second part. Is maybe I will put for next week something about the second part. So not compulsory for everybody to attend. Don't count
It's,
this within the, yeah, 2 classes. It's going to be like extra classes. Anyhow, I have the recording. You have got the already recording for that. Yes. So yeah, thank you for reminding me. We will do that on
I
8th.
think with the recording, it's totally fine.
Okay, if that's the case, then it's okay.
So another question: when do you expect us to submit the answers for these questions that you are giving
As
us?
long as
By the
you are
next
giving by
class,
tomorrow,
or you can do it by email or
better.
WhatsApp?
Yeah, better if you can give me tomorrow, I will give you. Okay, so as long as you are giving, I am going to give you early as possible. So once you send, I will send the reply to me. Okay.
Mr. Munas, also there is a question regarding to the last lecture. You told us about some extra lectures regarding to the acceleration of the course or something like that.
Yeah.
So, but you said that it will be this lecture. You will ask the other attendees to check their availability or something. So it will be accelerated this course, or it will be the same pattern.
Repeat the question again.
Yeah, last lecture you asked us to. You told us this lecture you will decide if we'll go to acceleration for the extra
Yeah, we are
classes.
talking. Yeah, we are talking about that only on 15 and 22.
Okay.
Yes, we'll do that
Okay.
on 15 and 22. So
All right.
And
All
next
right.
then,
class we'll continue with the first major, and we will finish it off.
and then
All right. Thank you.
timetable, that timetable you have to revise, I think.
No,
Revised
no,
one,
no.
you
We
have to.
will, we will, we will keep it as it is for now because we know what other
Mhm.
subject we are going to do, right? So
Yeah,
it
yeah.
is we will do once we done some extent. Anyhow, now according to the timetable, post contract only now going on. So once the post contract finished,
Mm-mm-mm.
that time we will revise the timetable, including the pre contract. So
Okay,
then
okay.
it's better. Otherwise, it will be a kind of a confusion. Say sometimes we don't agree the time to put. So I think today you all agree for a 15 and 22 because you people said you are busy in the beginning of the weeks and the end of the weeks. So that's what I am putting in the middle of the weeks. I will tell the title because it is, I think, no need to attend the batch number 24. You already covered, but if you want, you can request the next class. We will, 1 second, okay? Since you asked about the title, let me tell about the, 1 second. Just bear me with some time. I send you the revised timetable for old pages. So if anybody from the old pages won't attend, okay, you just request the link. I can send you. So we can start the
It
type of
should be on.
contract we will do online. Okay, we will do 2 lectures, which is tendering. Okay, tendering. So we will try to finish it within 2 days. I mean, 2 classes. It's achievable. Is it clear? Tender. Okay. Or we can do form of contract and the principle of measurement, whichever it is. Still, you have to go through. I think form of contract and the principle of measurement also possible. Which one all of you prefer? 18 and 25. No, we agreed on Sundays. Okay. Yeah. So we'll do the form of contract and the principle of measurement. Yes, that's fine. Okay then. Okay. In the slide, okay, I send the slide. There are 2 slides are repeated. Okay, so cut the slide number 39. Same questions are repeated on the 40. So there's a small mistake. Just ignore. I will send you otherwise the updated notes. Okay then. So good night to everyone. See you all with the next class.
Okay, good night.
Good night.